get some legal analysis on the Ace Magashule corruption case. We're joined now by legal expert Tyrone Maseko. Tyrone, thank you so much for joining us. So, and you'll correct me where I get this wrong. The pre-trial hearing into the criminal matter, that's been postponed to June. But the civil case, which has been launched by 4 of the 15 accused, continues tomorrow. Explain how a civil case can sort of operate alongside a criminal case. Is this quite normal? Does this sort of thing happen fairly often?
Good evening, Sally. Civil cases are very distinct to criminal matters. You know, you can institute a civil case in respect of just about anything and everything, really, for as long as you've got the facts to sustain it and the evidence. So I'll be frank with you, I'm not quite sure and clear as to exactly what the civil action is based on, but from the little that I've heard and that I've read, it sounds like an application for a permanent stay of prosecution. That's, you know, forget what they call it, but I mean, remember that we determine these things. The reason why we call it a permanent stay of prosecution is because of the remedy that you seek from the court. So if you're asking the court to stay permanently your prosecution, that's what we call it. So they haven't called it that, but it seems, and I've not seen the papers, but it seems that they're asking the court to quash the charges, and so for the criminal proceedings not to proceed, and that's a permanent stay of prosecution. You know, they'll have to. It's very difficult.
Yeah, I mean, yeah, they are asking for the charges to be dropped, and as you say, that's asking for a stay of execution. Why wouldn't you put that within the criminal trial?
So what happens is, remember that the criminal trial per se has not started, so we're still really busy with the systematic preparations leading up to the trial. So the trial really proper starts when the accused pleads to the charges. So the charges are put to the accused, and the accused pleads either guilty or innocent, not guilty. Then the trial is underway, and at that point, the accused is entitled to a verdict, whichever way things go. What happens is, if the accused is then of the opinion that, well, these proceedings really should come to an end for whatever reason, and typically, you know, permanent stay of prosecutions are very, very difficult to sustain, but typically it's something that you would raise where the way that the prosecution is being conducted is such that it renders a fair trial impossible, that it's simply not likely that you could have a fair trial. So a typical example would be where the prosecutor has interfered so much with the witnesses and influenced them to such a degree, I mean, drafting statements for them which are untrue. In that instance, it becomes unlikely and improbable that you could ever run a trial like that, because you still have to call the same witness. You cannot manufacture witnesses. Witnesses are who they are. Whoever saw the incident is the person that saw it. You cannot replace them with someone else if they've now been influenced and you're not able to determine, well, what is fact and what is not fact anymore. Remember that the courts rely on evidence, and that evidence has got to be credible. So if you get to an instance where it's not possible to determine whether witnesses are credible or not because they've given so much conflicting evidence, then in those circumstances, it could be said that it's not possible to have a fair trial. Now, back to your question, it's difficult to say without seeing the papers again exactly how they've couched the application. We'll know more tomorrow. So no, it's not rare to have these things. We saw it with the Jacob Zuma matter, for example. They went to the High Court for an application to stay the proceedings. They were rejected. They had to come back and proceed with the criminal trial. It's highly unusual, but it does happen.
One of the things I've heard often is that the proving a case in a criminal matter, the bar is much higher than with a civil case. Does that apply here, do you think?
Well, yes, but remember, we're also dealing with two totally different things. In the criminal trial, we try, in this case, I think it's charged with racketeering and theft and the like. That case is going to be concerned with evidence of, has there been theft, you know, has weight of money or whatever else has been charged with. We'll see the detail when the indictment is released. But there, what is being proven is the elements of the crimes, racketeering as well. And racketeering is very complex because it involves the participation of others. You cannot be charged with racketeering if you acted solely. But in the civil case, yes, they do have different standards. But in the civil case, they're not concerned with a person's guilt. They're concerned with, as I've just explained, the determination and what the court is asked to determine is whether here there are prospects of a fair trial. And remember that the fair trial is really the duty of the court that is trying the matter. The judge has to ensure that you're getting a fair trial. It's not the duty of the state to give you a fair trial, as it were.
So I want to just, one of the things that I think is coming up, and this is to do with the four in the civil matter, Ace Magashule, Edwin Sodi, the businessman, then we've also got former Human Settlements DG Tabani Zulu and former head of Free State Human Settlements, Intimotsi Mokesi. Now, Mokesi's lawyer is apparently saying he was arrested straight after he appeared at the State Capture Commission. His lawyer is saying, well, he incriminated himself, and what he said at the State Capture Commission cannot be used against him. Is this matter clear or not? You know, that what you say at the State Capture Commission can be used, because my understanding is the rules changed, and is there clarity?
Yeah, look, it's neither here nor there, to be totally honest with you. It's really, I think people get bogged up in all of this stuff. It's useless as far as I'm concerned, for the simple reason that there was nothing in the proceedings of the State Capture Commission that said that all other investigations that had been initiated prior to the State Capture Commission being launched, or any other proceedings were ongoing at the time, that those had to cease in preference for the State Capture Commission. There was never anything like that. So if you're being investigated or anything and there was evidence of wrongdoing, quite frankly, the police, the Hawks, could completely ignore what is happening at the State Capture Commission and arrest you. So, and they also don't have to say, we are arresting you because of what you said at the State Capture Commission. All they have to do is to say, we've got evidence of wrongdoing. We've got evidence of an offense here. We'll tell you what the offense is. Eventually, we'll tell you who the witnesses are. We'll give you disclosure of the evidence that we had. We don't have to tell you where we've got the evidence. And we prosecute our matter. Our only duty is to present our case and prove it beyond reasonable doubt, not to talk about how we obtain evidence. In fact, they can have derivative evidence, which you derive, but you do your investigations from what happened or a lead that you would have gotten. You don't have to show what the lead is.
All right. So Magashule's team is, they've slammed the NPA. First of all, they say, you changed your mind about the state witness. And this, of course, is his PA, his former PA. She is now going to be extradited back to South Africa. And it seems that they were probably trying to get her to turn state witness, and she decided not to. So now she's going to be charged. But the Magashule's legal team slamming the NPA for that. Also saying you never gave us the list of witnesses. And the NPA saying that's absolute rubbish. We did. Ace Magashule saying there's no charge against me, but there are clearly charges against him. And under all of that is him saying this is politically motivated. So my question to you is, how would we know if this is politically motivated or not? Is it all down to what comes out in court at the end of the day?
Absolutely, absolutely. So your last point is spot on. Completely irrelevant, the question of, in fact, motive is not required in any of the offenses, not that I can think of anyway, in any of the offenses. So you don't have to prove what motivated a particular part. So, for example, you don't have to prove what motivated a complainant in laying a complaint. All that we are concerned with is there a complaint of an offense having been committed? Are there facts? Is there evidence that sustains the complaint? So, put differently, could the state, is there what we call on the face of it, a prima facie case? Is there a prima facie case here where we can prove that these are the elements and this is the evidence, and we would have proven this beyond reasonable doubt? As to why we initiated the prosecution, that's completely irrelevant. So I think they should concern themselves with, is there evidence? What is the evidence? Now, back to the question of witnesses. Yes, you do have to state, you do have to, gotta be careful with this. You don't have to tell them which witnesses you're going to call, but what you do have to do is to give them access to what we call disclosure, to the statements of the witnesses. So they have to know in advance essentially what these witnesses are going to say, because they require it in order to prepare their defense. In this country, our legal dispensation is such that we don't operate on surprises. You cannot rock up on the day with a whole lot of video footage and photos and the like and present it for the first time when the other side has not seen it. We don't allow that. You got to disclose witness statements of the others. So if I've disclosed all the witness statements, then you can infer, and this witness statements bear the names of the parties, you know who the witnesses are. And the caveat is also that I'm not compelled as the prosecutor to call all of these witnesses necessary. So I may have 100 witness statements. It does not mean I'm going to call all those witnesses necessary. So there's a little bit of gamesmanship going on here. And finally, yes, you're right. It seems that in this instance, they actually intended to call his PA, who seemingly, depending who you believe, was state witnesses and has since seemingly, again, changed their mind. This happens from time to time, and it could be that the state is seeming to also to coerce her, or they've accepted that, well, if you don't want to testify, you change your statement, we're going to charge you with perjury. These things happen. We don't know why she's changed her mind, if she's actually changed her mind, but this is par for the course in these types of matters.
All right. Well, thank you so much for breaking it down for us. I do appreciate it. Legal expert Tyrone Maseko there.